Welcome, friends. Today we are going to discuss a very important topic, which is Supreme Court's judgment on 2G spectrum dated 2nd February 2012. Now, reason I brought about this topic for discussion is that this topic is highly misunderstood, right? And it is important that we take some effort to take you through the nuances of this judgment. And after having gone through this presentation, you will yourself understand that in what circumstances this judgment is applicable and what circumstances this judgment is not applicable. In the current situation, in the current context, this judgment is quoted in every situation of spectrum assignment. And that is where I believe that we are going wrong, because Supreme Court has been very conscious when it came out with this judgment to define under what circumstances this judgment will be applicable, and that is very conveniently or ignorantly ignored. So that's the whole purpose of this presentation, to take you through this judgment. And while we do this when I do this presentation, I have consciously kept in mind one important fact, that all the slides that I have created for this presentation has been extracted out of the judgment of Supreme Court verbatim. I have not made any changes on the bullets. That's why the bullets have gone a little lengthy, and therefore I have to highlight certain sentences or phrases in this bullet in order to make those clear, or if for my benefit as I take you through this presentation. So without wasting any more time, let's go to the second slide. Now, if you see this slide, the most important, the way the judgment has to be read and the way the judgment has been anchored by Supreme Court is by laying out certain questions which was basically put forward by the petitioner. And what were the questions which were analyzed in this judgment, and the answers were put forward by the Supreme Court after making a very clear and analytic conclusion. Now, these are the 5 questions. Now, these 5 questions, if you read these 5 questions, it basically says that whether the government has the right to alienate and transfer or distribute natural resources or natural asset otherwise than following a fair and transparent method, which is consistent with the fundamental right of equality enshrined in the Constitution, which is nothing but Article 14. The second question that it analyzes and evaluates is whether the recommendation made by the TRAI on 28th August 2007, and this is very, very important because this is the foundation on which the mess got created, the 2G scam. So-called 2G scam got created because of this recommendation. So this recommendation was evaluated, whether this recommendation was in contrary to the decision which the Council of Ministers took on 31st October 2003. Now, I will take you through the decision of the Council of Ministers in the next slide, and you will understand that how Supreme Court concludes that this recommendation is not in alignment with the decision which the Council of Ministers took on 2003. Then the third important question, basically the Supreme Court analyzes, is whether the exercise of DOT to grant those licenses in 2007, between 2007 September and March 2008, vitiated the environment, and it was considered arbitrary and with malified intent, and it's contrary to the public interest. So this is what Supreme Court is investigating. And then it goes on to further investigate the next question, whether the policy of first come first serve followed by DOT for grant of licenses is ultra vires and against the principle of the Article 14 of the Constitution, which is basically enshrined as a fundamental right, which we have mentioned in question number 1. And then finally, whether these licenses are liable to be quashed if these questions were found in the affirmative. Now, before I go into go and take you through this judgment, go further and take you through the judgment, it is important to understand from a policy framework what mistakes we were committing since the beginning, starting from 1995 when the telecom sector was liberalized and private sector participation was introduced. The fundamental flaw that India adopted in privatizing or granting license to private sector is that it adopted a policy of auctioning license than spectrum. Now, why it is important? Why this particular point is important that India adopted a policy of license than auctioning spectrum? The reason it is important is because the value of the license depends upon how many people are active at a time, which basically means that if you auction license, you are basically auctioning the permission to operate in a particular market, which means that a bidder evaluates the value of the license by determining that how many players are going to be operating at a time. If you come out with a new set of licenses or a new, if you suppose, let's say if you hold another auction after a few years for inviting new sets of license, then the valuation which the operator did at the time when he participated in the auction and the first round of auction, that valuation will be going disarray. The value of the license will diminish because more and more players got introduced in the market as the policy or as the decision of the government to auction in new sets of license. That is why auctioning of license actually it is not a right thing to do, because it kind of creates a perception within the operator that he is buying the right from the government to exclude others. It is very, very important to understand this. He is buying the right to exclude others, and if you violate that particular right, then the foundation of the auction actually gets disturbed. There is no way to justify the auction process, and that is why auctioning of license is not done anywhere in the world. Any of the developed economies do not follow auctioning, the principle of auctioning of license. They actually auction bottleneck resources like spectrum or any other bottleneck resources which have limited in capacity and where those resources can't be created, manufactured or multiplied using any other means. They are natural resources and their quantity is determined by the law of nature, right? Which is, therefore, spectrum is one of the things. The second flaw is that the license bundled the spectrum. Whatever spectrum that you assigned to the operator was bundled with the license, and the operators didn't have the right of getting spectrum arbitrarily. Though there were certain rules which the government of India had framed for assignment of spectrum, but those rules were arbitrarily changed and they were determined by technology specific metric, and these technology specific metric were changed on a continuous basis, which basically let me explain what I mean by this. That at the time when the licenses were granted for mobile services, then the government of India adopted a policy of assigning spectrum based on subscriber based criteria. Now the subscriber based criteria is nothing but a technology specific metric which the government of India adopted, which means that if you need a certain quantum of spectrum in order to pack so many subscribers in a particular block of spectrum, then you will be granted that particular spectrum. So in order for you to ask for a new block of spectrum, you have to justify that criteria, means that you need that quantum of spectrum. Unless you have that many subscribers, the government of India is not going to give you that. Therefore, for GSM, which was an inefficient technology, more spectrum was granted, and CDMA, which was an efficient technology, less spectrum was granted, even though lot of spectrum lay unused as far as CDMA is concerned, because the constraint of spectrum was mainly on side of GSM than on CDMA, but CDMA got deliberately blocked and was not able to unlock the full potential of the technology, like giving wireless data services. If you recall, the CDMA actually had wireless, it was able to connect with using dongles, computers at that particular point of time. There was e-video technology, which was all there, but those technologies could not be unlocked, and therefore the consumers got deprived of the benefits of the technology because of this technology specific spectrum assignment criteria. Third important thing is that the subscribers criteria actually got changed dynamically, means that government of India kept on revising the amount of subscribers that are needed for the operators to seek a certain quantum of spectrum. So their logic was that as the technology is progressing, it is becoming more and more efficient. Therefore, the operators need to adopt the latest and the best technology, and therefore it requires less spectrum. The flaw in this logic was that once you deploy an equipment for a particular technology, that the life of the equipment is at least 5, 6, 7 years or maybe 10 years. You do not change the equipment on a dynamic basis. If you want the operators to change the equipment on a dynamic basis, then you actually have to create incentive, not disincentive. And also, there are certain operators like CDMA players who actually had the capability to deploy various services, data services in their same block of spectrum, were prevented from doing so, forcefully, because they were told that if you try to use your technology for, it was basically not written anywhere in the government dictate, but it was a kind of an unwritten message from the government that if you are going to use for your spectrum for data services, then you are using your spectrum inefficiently. So that actually resulted in lot of consumer harm, because consumer were not able to use those services. So these were the three flaws. Probably you have understood, and these are very important to understand, because without these you will not understand what the Supreme Court did and how we are basically misinterpreting the Supreme Court judgment from the point of view of achieving some vested interest. Because everybody is not misinterpreting. There are certain vested interests, or out of ignorance or out of intent, both, which misusing the Supreme Court judgment to prevent certain policy level action from the government, which is for the interest of the country and the consumer. So let's go to the next slide. Now I would like to give you background here. The background is very important for you to understand. Now, as I told you, the government of India had a policy for auctioning license, not spectrum. But the government of India from the very beginning had an intent to come out with some criteria of pricing of spectrum, which is very, very efficient, and it kind of reflects the incentive to the operators to use spectrum efficiently. Like if you see in NTP 1999, it is saying that there is a need to have a transparent process of allocation of frequency spectrum, which is effective and efficient. Similarly, in 23 June 2000, TRAI basically says that the TRAI recommends all new operators barring DOT must be selected through a competitive bidding process. Now here TRAI is talking about auctioning of license, not spectrum. Then in 2003, TRAI recommends that operators shall require to approach the licensor mainly for spectrum allocation. Means for license should be granted through auction, but once you have the license, then you have to go to the government for spectrum allocation, which means the discretion for allocation of spectrum rests with the government. It was never transparent. Even though there was a mechanism of auction, the allocation of spectrum criteria was never transparent. It was always under the discretion of the government to give to the telecom operators spectrum based on what they decide at that particular point of time. Then in 30th October 2003, GOM recommended that the DOT and the Ministry of Finance should discuss and finalize the spectrum pricing formula, including the incentive for efficient use of spectrum. Now this is very important, because the Supreme Court kept on emphasizing on this point. Means all the actions which were taken going forward after 30th October 2003, that is the decision of the GOM, which GOM recommended to DOT that they should, both the DOT and Ministry of Finance should basically collaborate and decide. They never fulfilled this recommendation of GOM. So this is very important. That's why I marked it marked with red. Now on 24th November 2003, Ministry of IT took a decision that as regard the points raised about grant of new license, it will be on a basis of first come first basis, and the announced guideline has been made open for new license to be issued on a continuous basis, which basically means that the Ministry of IT and Communication decided that they will continue to grant new licenses on a they will continue to grant licenses, and those will be granted without any restriction. But for spectrum, if the operators need spectrum, that will be subjected to availability. Now it is very strange thing. Now most of the operators who wanted their license at that particular point of time, they wanted license for what? they wanted license to basically do mobile services. Now, why would I require license? I would not I don't need any license basically to, for me the license does not have any value if spectrum is not attached to the license. But because I told you that spectrum allocation was always discretionary, so the government of India said that even though you can apply and we will grant you the license, but we will not grant you spectrum. So therefore, you paying for license does not make any sense. Because why would you pay 16,000 crore, which was the fourth cellular auction, the price which was discovered for a license which does not have any spectrum attached to it? So it's very, very weird and illogical for the government of India to do that at that particular point of time. Then in 2006, once the government realized that there are many flaws in their spectrum assignment and the licensing policy, they basically decided to form a group of ministers. They basically form a committee based on group of ministers with a reference to exclude spectrum, with a reference to basically decide on spectrum pricing. What should be the pricing of spectrum? But because of, at that particular point of time, it was a coalition government, and because of the pressure which actually was felt by the coalition ministry, this spectrum pricing policy was excluded from the terms of reference of the GOM. So that actually was one of the opportunity that the government of India had to correct all the past mistake, but somehow it could not get corrected because of the disagreement between the ministries, the Ministry of IT and SC judgment clearly points out to this particular fact. If you look at this, what SC judgment, SC says, Supreme Court basically says, just give me a minute, says that, the Ministry of, sorry for this because the mouse is basically not operating properly. Just give me a minute. Let me stabilize it. He said, the Ministry of IT appears to have protested that terms of reference would impinge upon the work of his ministry and requested that the terms of reference be modified accordingly with the draft enclosed the letter. Right. Now let's go to the next slide. Now, as I told you that the TRAI recommendation of 2007 was very, very critical. Now, if you look at this particular recommendation, you will find that this recommendation, though the intent was good, but the problem that with this recommendation was this was vague. It did not specify anything clearly. What mistake it committed? Let me just tell you. Let me first tell you what was the good that it did in this recommendation. It basically recommended for auction of all spectrum other than 800, 900 and 1800 MHz band, which are the 2G band. But the mistake that it committed in this recommendation was that it said that for 800, 900 and 1800 MHz spectrum, they didn't recommend any auction. Right? They said that they will continue the same process of assignment of spectrum through subscriber-based criteria, through first come first serve basis. Now, what is the problem with this recommendation? The problem is that in one hand, the TRAI is saying that there are no restriction on the number of access providers in any service area. That is what the recommendation is. And then on the same breath, it is saying that these precious resources, which are scarce, which is 800, 900 MHz spectrum, the 2G spectrum, that there is no need to follow any auction procedure. Now imagine if there is a demand, a huge amount of demand in 800, 900 and 1800 MHz spectrum, which actually happened in 2007 and 2008, and I'll tell you the reason why it happened, then how will you break the stalemate? How will you decide who to give, who not to give? The TRAI has to spell out very clearly, ki look, if they are proposing that the number of subscribers, number of access providers in a particular service area should not be restricted, means there is no cap on the number of operators operating in a particular service area, then on the same breath they should have recommended that how to deal with a situation where number of players are applying for the same quantum of spectrum which is restricted, which is very less, means demand is much higher than supply. So the TRAI did not give any recommendation on this, and that became the foundation of this scam. Because if TRAI had given a criteria how to break the stalemate when demand is much higher than supply, then there was no way that the mess could have been created at DOT or at any other level, because the TRAI recommendation was used as a reference for all kind of discussion which happened later. So that was the basic problem with the TRAI recommendation. But the TRAI did say that the price which got discovered in the fourth cellular license, and if you are going to give, because as I told you earlier that the government of India had a policy of giving license on a continuous basis, TRAI basically said in its recommendation that this price is not realistic, and therefore perhaps there is a need to reassess through a market mechanism. But again, look, this is vague. Perhaps means what? If you feel that the price is not realistic, you as a technical body should have the power and the intent to give a clear-cut recommendation what the price should be. You cannot leave that decision based on to DOT, because you need to do a complete job, and that is where the issue was. And then one more point was that the TRAI basically said spectrum allocation criteria and the pricing methodology of managing suffer from number of deficiencies. It basically said it also said that the authority recommends that this whole issue should be dealt in a holistic manner, not in a piecemeal manner. But again, you are leaving the ball in the court of DOT. If you felt that this particular issue is piecemeal, then you should have given some recommendation how to deal with it. So that's why I basically say that this recommendation of TRAI was not complete, and it was vague, and it was misused later, right? By people who really wanted to manipulate the system. Now, what the actions DOT took? Now, DOT basically took the TRAI recommendation and decided unilaterally without involving all the members of the Telecom Commission. If you see that Telecom Commission consists of Finance Secretary, Department of Industry Policy, DIPP, Secretary of Department of Information, they were not even called for the meeting. And then in the meeting, Telecom Commissions only was attended by DOT officials. They decided by themselves, what they should do with the TRAI recommendation. Neither the internal committee of DOT took any action on paragraph 2.4 of the recommendation, which I told you, that it is not piecemeal, we have to take a holistic. So they didn't do anything on this, right? And they left it like that. And DOT also did not get in touch with the Ministry of Finance to discuss and finalize the spectrum pricing, which the cabinet took the decision in 2003, which I pointed out here. So none of this was done at that particular point of time by DOT. Now, what is the DOT's initial plan to deal with the barrage of license requests? Now, before I take you through this chart, I would like to tell you that what was the reason for this barrage license or request, means why there was such a flood of requests for license which was not there earlier. The reason it was that in the TRAI's recommendation, which I did not lay out because the Supreme Court judgment does not talk about it, therefore I left it, but I'll tell you orally what actually happened. In the same recommendation, as I told you, the subscribers criteria, which was linked to the efficiency of a technology. So what TRAI did, that because there was no spectrum in the 1800 megahertz band, it was all booked by the existing operator, because if you apply the subscribers criteria, the old subscribers criteria, then they would have taken the full 1800 megahertz spectrum and the 900 megahertz spectrum. There would not have been any spectrum left to be given to the new licenses. So what TRAI did, they enhanced the subscriber-based criteria multiple times. Means now for an operator to be eligible for more spectrum, he had to meet the criteria 4 to 5 times than what he originally were required to meet in order to get additional spectrum. So that because of that, what happened was that more spectrum got released, and because more spectrum got released, and because of these reasons that the DOT took at that time, that they would continuously encourage licensing on a continuous basis, means they will not stop licensing. There was a barrage of applicant, because earlier there was no spectrum, so nobody applied. Now since the spectrum got unlocked because of the TRAI's revising the subscribers criteria, there was a barrage of license, and now TRAI at that time did not even state that how to deal with this stalemate. So this laid out a huge confusion. So what happened was DOT, under the member technology, which was basically an ex-officer secretary to the government of India, laid out a plan, because TRAI did not say anything. So let's DOT's responsible officers of the DOT try to salvage the situation. So what he said in that note which he sent to the law ministry, he said that since there are a lot of applications, we cannot deal with them. So what he said that, however, those who fulfill the LOI, means everybody will be given a chance. Everybody will be allowed to apply. Whoever applies first, means suppose let's say I as an applicant apply first. Date of application will be taken as the date of considering me as in the queue, not the date of payment or any other criteria. Means once I make the application, if the DOT rejects my application or asks me to fulfill some other condition, till the time I am not completely rejected, the application date will stand firm. This is very important to understand that the application date was used as a reference for deciding who will be in the queue, first in the queue, or who will be the second in the queue, will be the third or fourth, etc. Right? So this was very, very crucial, and that is the right thing to do. First of all, it is basically not right to give spectrum on first come first basis when there is such a big huge demand of this. Supply is so less and demand is so high. Because if there are 100 applications, all will meet this eligibility criteria or the LOI condition, how will you decide who to give, who not to give? You would immediately unwind the whole process and auction it. That's the same thing to do. But what happened was, once this note went to the law ministry, then the law ministry of justice got confused. He understood the problem. So he said that the whole issue should be basically dealt by the empowered good of minister. And he took the right decision. So there were very, very sane people in the system who wanted to take the right decision. But what happened was, the MOIC, Ministry of Telecommunication, he recorded on the file saying that no, this is completely out of context. He wrote to the Prime Minister saying it's completely out of context. PM in his response tried to convince the telecom minister, but he was unsuccessful. Even the finance secretary wrote to the telecom minister saying that there will be a huge financial implication and the whole things should be revised and pricing has to be done afresh. But DOT secretary wrote back to the finance secretary saying that in 2003, which I pointed out here, DOT has been, by the GOM basically decided. So he basically picked the facts of that GOM recommendation of 2003 out of context, saying that DOT has been authorized to finalize the implementation. And then then one most important thing that the telecom minister did was, he changed this logic, which was proposed by the member technology, that the seniority will be decided by the application date, and he changed it by saying that the seniority will be decided by who fulfills the conditions of the LOI first and who pays, who makes the payment. Means LOI condition can only be fulfilled when you make the payment, right? So there was a lot of opportunity to kind of manipulate the system or play with the system in between. Suppose let's say if I make an application and you find a flaw in my application, and then you ask me to fulfill the criteria again or maybe revise my application, and in the meantime somebody else basically goes up in the queue and you grant him the license because I am not fast enough to comply the LOI, then my seniority in the queue get pushed behind. So that is the opportunity of manipulation, right? So now let's go to the next slide. Let's now discuss question by question of the Supreme Court judgment, which is basically the meat of this presentation. Now what Supreme Court is saying on question number 1, whether the government has right to alienate and distribute natural resources otherwise than following a fair, transparent and consistent with fundamental principles of equality enshrined in the Constitution. Anybody, who actually believes in the Constitution will say government does not have right to distribute natural resources without following a fair and transparent and consistent method of equality. So naturally the Supreme Court did that, but it is important to understand here and point into the Supreme Court judgment where Supreme Court is saying that natural resources value rests in the amount of material available and demand for it. So if there is a demand for a particular natural resource or a quantum of natural resource, there is no other way of assigning that resource without transparently following the method of auction. It's very simple. But if there is no demand and if the quantum of resources that is available is much higher than the demand, then you could have another way of allocating natural resources without following through the process of auction. So this point about Supreme Court is missed by all analysis. everybody who's trying to interpret the Supreme Court judgment, they don't really look at this particular point that the natural resources value, Supreme Court mentions, the natural resources value rests on the amount of material available and demand for it. And it also continues to say, spectrum has been internationally accepted as a scarce and finite and renewable natural resource. Now the point here is that this is a perception Supreme Court had because of the nature of assignment which was made at that particular point of time. But it is not all inclusive. There are certain spectrum which is not finite, which is not scarce, like for example satellite spectrum, backhaul spectrum, where you can actually give spectrum based on link by link basis, and you can segregate the allocations very close in nature, because the point beams are so pointed in a particular direction. You can keep assigning spectrum to multiple operators and reusing the band without the spectrum getting scarce. So under those circumstances, applying the Supreme Court judgment without applying your mind to what Supreme Court actually meant and what is the foundation on which his judgment is based, which says that resources value rests on the amount of material available and demand for it, then only you can under these circumstances, then only way to assign resources is by following an auction as a method. Then only the transparent and fair allocation can be done if the demand is much higher than the risk. That is the fundamental premises of this judgment, which is missed out when people quote and say that every kind of spectrum should be assigned based on auction. So that fundamental premises is missed out by the fact that the natural resources in question should be scarce. Unless natural resources is scarce, it is impossible to make that assignment, right? If it is scarce, then you cannot make that assignment without following the process of auction, right? So that is why in 2G the demand for spectrum was very high. There were a lot of people who were in the queue, and therefore auction was the only way of assigning spectrum, right? Now coming to the question number 2, whether the recommendation made by TRAI in 2007 for grant of unified service license with 2G spectrum 800, 900, 1800 megahertz band at the prices which was fixed on 2001, which approved by the DOT, was contrary to the decision taken by the Council of Ministers in 2003, which I mentioned. The GOM basically wanted to reprice spectrum at that time. They made that attempt in 2003. Here also it's very simple to understand, as I told you, that TRAI actually made a vague recommendation when it said that there is no cap, and on the same breath it says that the spectrum of 2G spectrum cannot be auctioned, and then on the same breath it basically came out with a subscribers criteria which is 5 times what the subscribers criteria was before this recommendation. Therefore it created a very large quantum of spectrum. It did not lay out any rules for assignment of the spectrum. Naturally, the mess would have been created. Anybody would understand with some sense of logic, right? So naturally, TRAI was completely wrong in making a recommendation which Supreme Court recognizes, and it says that TRAI did not follow the rules, the principles of basic regulatory framework, and it also did not follow, it did not recommend any standard pricing option for 2G band, which I told you, right? And also TRAI recommendation made by TRAI in this regard contrary to the decision of the Council of Ministers. And then the third and the fourth question, whether the exercise of Supreme Court, whether the exercise undertaken by DOT from September 2007 and 2008 for the grant of unified license to the private respondent in terms of recommendation made by TRAI is vitiated due to the arbitrary and malafide and contrary to the public interest. Now, probably after you have gone through this presentation, you yourself will understand that it was actually arbitrary and it vitiated the public interest, because none of the principles of regulation and natural justice was followed, right? And he says that, SC says that there is a fundamental flaw in first come first serve. So when he says there is a fundamental flaw in first come first serve, it is basically pointing to this point of reference which is made. In natural resources, value rests on the amount of material and the demand for it. It is very important to understand it is not out of context. And every time this particular point is quoted out of context, which is a problem, right? So there is no way to assign natural resources based on first come first serve if the demand is going to be much higher than supply, right? That is where the problem in this particular case was. If the demand is going to be much less than supply, then in that case, the Government of India or any other regulatory agency can assign spectrum without following auction. the principle of transparency or any other natural justice will not get violated, because if there are only two people standing in the queue, and if there are hundreds of megahertz of spectrum available to be given, just like what is happening today in the auctions. If you see every auction, if the government lays out all the spectrum band, only 10% or 20% is taken, rest of the spectrum is again goes back to the government kitty. So is this an auction? Is this an auction process? What kind of transparency that we are achieving out of this process? See, the transparency, if the demand is going to be always going to be less than supply, then you can adopt any other mechanism like satellite spectrum, micro spectrum, even access spectrum. It basically clearly proves that the auction design is flawed. If you are going to have, if you on a first premise you say spectrum is scarce, and the second premise you say that I only auction as a method is transparent, that I have to follow in order to allocate these resources. But when the demand is going to be much less than supply, then there is no need for you to allocate the spectrum through auction, or your auction design is faulty, which basically creating a situation where the market is becoming more monopolistic. So you should be conscious about the fact that you are, as a regulator, as a government, is contributing to the market becoming more monopolistic in nature, because the demand is much less. It's not about maximizing resource, because if you keep 90% of your spectrum unused, or critical bands like 600 megahertz band unused, 700 megahertz was kept unused for 10 years, which is the most valuable spectrum from the point of view of in-building penetration, from a mobile broadband perspective. And even today, 5G does not have low frequency band from a mobile perspective. So you will not be able to unlock the full value of spectrum. So what is the point in keeping spectrum fallow, right? When you are not going to, unlock the full potential of your technology. So therefore, the design of the auction also becomes in question, because if the demand is much less than supply, and therefore that also has to be taken into consideration. So I think you probably understood that, and then it basically Supreme Court in this two question also says that when it comes to alienation of natural resources like spectrum, right? Yeah, let me go to the spec question again, and I'll conclude by this. It says that when it comes to alienation of natural resources like spectrum, it is a burden of the state to ensure non-discriminative method adopted to distribution of its distribution alienation, and it is a duty for the state to auction is conducted for allocation, a best method of discharging the burden, and the method of first come first serve when it used for alienation of natural resources property are likely to be misused. Absolutely, when demand is much higher than supply, it is going to be misused as it has been misused earlier. There is no other way of allocating resources other than following auction. But if demand is less than supply, then you can follow any other methods. I think probably you might have understood now what is the premises of this judgment and how this judgment has to be should be applied in practical situations. Supreme Court never said that under all circumstances you should do auction, because it has to be, its judgment has to be seen under the context of what he's saying. It basically says that natural resource value rests on the amount of material available and demand for it. Not that, if there are no demand for a particular natural resources, there is ample supply, then there is no value. It is better to give away those resources free to the operator, so that at least some value can be generated. I hope that I made it clear. The video actually went very long. I had no other way to constrain it. Otherwise, I would not have done justice to the video. Thank you for your attention. And let me know if you have any further questions. I will be in your comment section. Thank you very much.